Hi guys, continuing on with the conditional acceptances page of my Law-5 website, which you can access by going to EmpowerYourLife.dev, scrolling down to the first image here, click on that icon, or click on the button here or where it says View Law Website, and then from the home page, if we go to the drop down menu, the top right hand corner, you should be able to see the drop down menu and the page at the top of it there. And when you click that, it takes you to this conditional acceptances page. This is part 2 of this page. I've already done a video on part 1, and we're continuing by talking about the coronavirus fine that I received. So if you click here, that'll take you to where we want to start. It says COVID-1984 fine received. Below is a copy of the coronavirus fine I received. I've taken my name and address off of the following documents, as I don't want unwanted attention from randoms at my address, obviously. This is what happened after. When coming back from the supermarket, I stopped by a bench which I had placed my shopping bag on in order to look at my phone. My end of the bench was empty, but as I got to the bench, another man wanted to sit down on the bench, so I was polite enough to ask first, at which point we spoke briefly for about 2 seconds. This is when the police came in and said to me, "What are you doing standing by a bench?" I kid you not. My reply to this was, at the same time as naturally laughing, "What do you mean? What am I doing standing by a bench? Is that against the law?" And that's where I left you in the previous video, part 1 of conditional acceptances. Part 2 is showing you how I applied conditional acceptances in real life against this coronavirus fine that they sent me and got rid of it, how I got rid of it. So continuing on with the story, they said, "We saw you talking to that man. That's against the coronavirus regulations." To which I should say I replied, "I'm not interested in regulations. I asked you if it's against the law." And they said, "You need a valid excuse to be out of your house," or something along those lines, which made me laugh even more. And I replied, "What is this, Nazi Germany?" The discourse continued with me asking questions like this for a while. In fact, the next thing they said to me was something like, "If you don't give us a valid reason for being out of your house, we're going to fine you." I'm just laughing at the audacity of their questions. Anyway, to which I replied, "Well, you can see my shopping bag there, but go ahead. If you want to fine me, I'd love to see that one stand up in court." After which they replied, "We don't believe you, so we're going to issue you with a fine under coronavirus regulations," or something. And then they fined me. I didn't think they liked me laughing at them. I don't think they liked me laughing at them, as they didn't seem to see the same humour in the situation that I did. I gave them my details as I thought it'd be a good example to use for this website. Plus, sometimes it's necessary in life to lose the battle, so to speak, in order to win the war. And although I knew this changes my status or gives them the upper hand in the moment, because statuses or contracts are fluid, I can easily change my status back by redefining the contract with a conditional acceptance. In other words, correct it in writing later, which is exactly what I did, as you'll see in a minute. Here's the fine I received. So this is from the Criminal Records Office, as you see. It says, "Dear, I've changed my name to John Doe. So, dear Nathan, read penalty notice, the health protection coronavirus restrictions, all tiers, England regulations 2020. A. Circumstances regarding the issue of a fixed penalty notice on 7th of the 1st 2021 at our side," and I've redacted the address, "High Street, London at 1510. You were found to be in contravention of the regulations as you..." Let's enlarge this. Here you go. Found to be in contravention of the regulations as you. It says it's not doesn't really make a sentence in English starting that way, but it says as you contravene a requirement to not participate in a gathering in any other outdoor place in the tier 4 area of 2 or more people. I guess a bot wrote this letter. Anyway, the particular circumstances relating to the contravention of the regulations are as follows. Subject was observed standing next to another member of the public in an outdoor place. The two people were talking to each other and were not from the same household, not social distancing. I can't help but laugh at this. The pettiness, man. As a result of the above circumstances, a decision has been made by the undersigned of Metropolitan Police Service to issue you with a fixed penalty notice in accordance with the regulations. B. Fixed penalty notice amount. The amount payable on being issued with a fixed penalty notice is calculated as follows. First fixed penalty notice. If this is your first fixed penalty notice issued under the regulations, it will incur a charge of £200. The £200 charge is reduced to £100 if it is paid within 14 days from the date of the fixed penalty notice. How kind are they? How kind are they? Second fixed penalty notice. If this is your second fixed penalty notice issued under the regulations, the charge will be £400. So that's double, or quadruple if you take the first amount. No discount is available for early payment. Further fixed penalty notices, so third or more. In the case of a third fixed penalty notice, £800. Wow. In the case of a fourth fixed penalty notice, £1,600. In the case of a fifth fixed penalty notice, £3,200. In the case of a sixth and subsequent fixed penalty notice, £6,400. No discount is available for early payment. Now, I don't know about you, but I'm thinking I'm in the wrong business. I'm sure you, wow, you'd have to, that's a lot to contend with, mate. You know, you'd have to be doing something special to earn that amount of money just for sending out one letter. Wow, that's some wang these people are making P, right? According to our records, this is your first offence. Therefore, the charge incurred is £200. As stated above, if this is paid within 14 days from the date of the fixed penalty notice, the charge is reduced to £100. Oh, they're giving me a discount. Oh, wow, that's a good way to do business, you know. I've got to take a leaf out of their book. You have 28 days from the date of this fixed penalty notice to make payment, during which time proceedings will not be brought in relation to the offence committed, contrary to the regulations. If payment of a fixed penalty notice is not received within 28 days from the date of this fixed penalty notice, then you will be liable to be served a summons to appear in court for the offence via the issuing police force. Bring it on. If in due course you are convicted by the court of this offence, the court has power to impose a fine of any amount. Oh, really? That's interesting. So they can charge me 50 grand if they want. Okay. According to them. The law S164CJA 2003 requires that the amount of a fine must reflect the seriousness of the offence. I don't find the offence very serious. And also that the court must take into account your financial circumstances. This applies whether it has the effect of increasing or reducing the fine. Guidance, there's a link there, indicates that normally a fine should be of an amount that is capable of being paid within 12 months. 12 months! So they could take my whole wages for 12 months, in other words, if they wanted. Is that what they're saying? Yeah. I conditionally accept that. There may be exceptions to this, though there may be exceptions to this, really. If you are convicted by the court, this may need to be disclosed via relevant criminal records checks. How to pay your dispute, the fixed penalty amount. Yeah, let's have a look at. I can pay within 28 days, option 1. Option 2, I can request a court hearing. If you wish to contest the fixed penalty notice and have your case heard in court, you must contact ACRO Criminal Records Office using details below in order that they can pass details onto the issuing police force. Yeah, right. Okay. Payment by post. Important note for all options. When corresponding with ACRO, you must quote the reference number, blah, 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 blah. Yeah. The fair processing notice. A record of this fixed penalty notice will be kept in the interest of the administration of justice in accordance with the issuing police force's data protection policies. The information may be used to help decide whether or not to issue you with another fixed penalty notice in relation to any subsequent offences for which such notices may be issued. The period of retention of this information is determined by an overall assessment of the nature of the information held about the individual. Relevant information held by police may, in certain circumstances, be disclosed to potential employers as part of a criminal records check, disclosure and barring service. Good job I didn't read all of this at the time. I might have been scared. Yeah, right. Oh gosh, all hot air and threats, mate. They're just trying to make me scared, talking about criminal records and my employer and all of that, and affecting work. Criminal Records Office is facilitating the administration of fixed penalty notices data processor on behalf of the police force, issuing the fixed penalty notice under the Health Protection Coronavirus Restrictions All Tiers England Regulations 2020. Robert Price, Chief Executive of ACRO Criminal Records Office, is the designated officer to whom payments are being made. Interesting, that. I'll leave you to read the rest if you want it. If you want to, because I think we got more interesting stuff further down in their second letter. Ideally, with any fines we are given, we actually want to pay them, and since the gold and silver has been removed and our signature is the money now, it won't cost us anything except some ink and a few calories and postage to settle this debt by Royal Mail signed for. This is actually money of substance too, and our paying in this way benefits the whole globe as it lowers the national debt of our country. There is a lot of understanding to do with bills of exchange, which is what we turn this piece of paper or any other bill for debt into once we sign it. I encourage you to read the Bills of Exchange Act 1882. There's a link to it there, legislation.gov UK. Or if you are in America or Canada, you'll also have your own country's Bills of Exchange Act. And there's also the UCC, Uniform Commercial Code, which governs the international law merchant, in brackets, merchant stroke mercantile law, to help forge your understanding. See the books further down. Here is the response I sent to the fine. I haven't received a response in over 13 days at the time of writing since sending this response, even though the letter was dated 2nd February and they gave me 2 weeks. Actually, it was 28 days. I didn't even read it properly. That's how seriously I took it. Read the 4 pages above this. it says. But here is a template. I've taken my name and address and everything off of the template. So as you can see, that's where my address, or that's where your town, your city, your house, your name goes, etc. And that's the response. Notice of conditional acceptance. The contract is the law. Notice to agent is notice to principal. This is not a complaint and is not to be treated as one. Dear Bob Price, thank you for your notice dated 1st of the 2nd, 2021. You'll understand why I cannot simply just pay all alleged debts without them first being verified. Let's zoom in again. So we can see the letter clearer, hopefully. So you'll understand why I cannot simply just pay all alleged debts without them first being verified. So in order for me to settle any debts which I may owe, please provide proof of the following in order for me to do so. Number one, proof that the Bill of Rights, which states that all grants and promises of fines and forfeitures of a particular person, actually it's of particular persons, before conviction are illegal and void, has been repealed. Number two, proof that the Magna Carta, which states in clause 38 that no official shall place a man on trial upon his own unsupported statement without producing credible witnesses to the truth of it, has also been repealed. Number three, verified proof that there is a man stroke woman claiming I owe him or her a debt. 4. Verified proof that there is a court ruling ordering that I, a man, pay you or anyone else anything. 5. Proof that an unrebutted affidavit does not stand as truth in commerce or law. 6. Proof that the unrebutted affidavit sent by Royal Mail signed for delivery number blah 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 to Prime Minister does not supersede any statutes or regulations you are attempting to enforce. 7. Proof that your notice of fine is not a false claim and that according to the terms of the above mentioned affidavit you in fact do not now owe me £5,000 for making a false claim. Please either A, provide proof of all 7 above points, or in the event you cannot provide proof, then B, rebut all of the above on a point-by-point basis, signed and sworn, affirmed under full commercial liability and penalty of perjury. Then, once you have done so, simply send me a bill in order for me to pay this alleged debt once it has been verified in this manner within 14 days, or I'll put that in red because you can change it to 28 or whatever. 28 is the usual, the standard. But if you're in a rush, you can change it to lower. If you cannot address all 7 points in the manner prescribed, then you agree that there is no proof of debt and that this matter is therefore settled and closed. Responses from anyone containing other than the 7 points outlined above or to confirm closure of this matter will be deemed as insufficient harassment and will be charged at a rate of £100, as will any further notices I am forced to write and stroke or phone calls and stroke or emails, plus a further £5,000 for any visits to where I live. Repeat fines and stroke or per further insufficient document I receive regarding this matter, since that will constitute your agreement by tacit acquiescence to the terms herein, as will your non-response within the 7 days or 14 or whatever you've given them. Fees and costs in accordance with the Litigant in Person Expenses and Costs Act 1975 will also be levied to recover in small in square brackets claims court by claims court any outstanding debts you accumulate if necessary. Yours faithfully, first name, family name, principal, your autograph, signature. Errors and omissions accepted. Calls may be recorded. So accepted meaning taken exception to, made an exception for. and then let's get that back to 100%. Oh, and then we have the template of that letter. Is a template of the above response in docx format or Word format, in other words. You can download. Here is their response received today on 15th March 2021 at around 3 p.m, which is over 4 weeks later. Yeah, I did say they gave me four weeks, but I didn't really read the whole thing. It was a bit long. The letter was too long for me to read, and I didn't take it seriously enough to read all of their threats and intimidation tactics. So, yeah, 12th of the 3rd, 2021, ACRO reference number. I've changed that. I think I've changed the name there. Dear name, re-penalty notice, blah, blah, blah. This is their response to my response, so this is their second letter. I refer to a fixed penalty notice issued to you under ACRO reference number blah blah blah, which I changed. The fixed penalty notice on 1st of the 2nd 2021, as the 28-day time limit for payment being made has now passed and a payment to settle your fixed penalty notice has not been received, your details will now be forwarded to Metropolitan Police Service. You are now liable to be issued a single justice procedure notice in relation to this offence. Please retain this letter for your records. So, because the police didn't like me laughing at them, they deemed me going to the supermarket was an offence. Oh no, sorry, they said me talking to a man that I didn't know was an offence. Right, whatever. So, even though the man sitting on the bench was further away than the police were standing in relation to where I was. Yes, and they're threatening me with a criminal offence basically. And it says, if you have a query regarding your fixed penalty notice, please refer to the frequently asked questions available here. The latest government advice on coronavirus can be found at, and there's a link there. Yours sincerely, Bob Price. Chief Executive Officer, who's making all the money. Wow, he's making a lot of money, mate, if people have been paying them fines. Here's the government website they directed me to about single justice procedure notice, about my single justice procedure notice, which at time of writing I await eagerly. So their response is, yes, so I didn't reply to that. Their second letter, their response to my first letter, or my first notice, and we continue. Their response letter above only proves one thing. We live with a tyrannical government, which means one that doesn't follow the laws. Actually, it proves two things. The other is that I would have been better off sending the first letter they sent me back with no contract return to sender written on front. And what I mean by that is they just ignored what I sent them and carried on with the first letter. That second letter, their second, sending me their response letter, their second letter. Update, case closed. Yeah, so I didn't respond, as I said, to their second letter. I just thought, okay, that's how you want to play it. Let's go to court then. So I ignored it. So update, case closed. I received the following letter today, 30th of the 12th, 2021. In response to my ignoring the threat of court from ACRO Criminal Records Office, as already detailed above, about my coronavirus fine, fixed penalty notice. I wasn't expecting to hear back from them after they said I'll be hearing from the court when I sent them a one-page conditional acceptance, but instead today I get a letter saying they're taking no further action as seen here, as shown here. And here's their response from 999 Let's-Be Avenue. See you, Jimmy. Interesting postcode there, eh? Yeah, I changed the names of the The names have been changed to protect the innocent, as it says in some good films that I've seen. Penalty notice: the health protection coronavirus restrictions, all tiers England regulations 2020. I refer to the fixed penalty notice issued to you under ACRO reference number COVID blah blah 1984. That's the official number, obviously. Not. On 1st of the 2nd, 2021, the issue in force have reviewed the evidence in relation to this fixed penalty notice and have subsequently made the decision to take no further action. What evidence is that exactly? The evidence that I said I'm going to charge you loads of money if you take me to court or if you keep harassing me. Yeah, it's probably the evidence they're talking about. Don't remember any other evidence. The case is now closed. Please retain this letter for your records. Please note, if you have already provided payment to ACRO, a refund will be processed immediately, imminently, according to the original payment method. You will receive further correspondence relating to this. The latest government advice can be found there, blah, blah, blah. Oh, well, cheers, Bob. It was nice interacting with you. Nice one, mate. The Crown Prosecution Service has now admitted in response to a Freedom of Information request that all offences charged under the Coronavirus Act were incorrectly charged. Yeah, I found that after I got their letter there. So I've shared the link to that if you want to read that. That's exactly what I've done in the past with fines. I even had one which went to a magistrate's court and was inflated to £550. All I did with that was the same. I wrote no contract return to sender on the front and sent it back to them. Here's what I did with the census that recently came round. It says addressee not known, return to sender. That's what I've put and crossed out the name. It says your response is required by law. Well, there's my response. Happy? And on the back I've put the Bill of Rights 1689, all grants and promises of fines and forfeitures ... before conviction are illegal and void. And they did send me a few more after that actually, and I just sent them all back the same way. And I never heard anything more of it. Oh, actually, tell a lie, I had somebody coming round ringing the buzzer and I said, stop ringing my buzzer please, and they never came back again. So the meaning of complete, because it says up there, oh no, sorry, I've had a look at the form that was sent in that census letter and it says you must complete this. Here it is. I've put it below. The meaning of complete. It's funny they use the phrase it is an offence to supply false information or to not complete the census, and you could be fined up to £1,000 on the census envelope, because when we look at the definition of complete at this website, actually I think it was on the form, I didn't see it on the envelope, but when we look at the definition of complete on this website, macmillandictionary.com thesaurus, it says complete, verb, to finish something. Yeah, so if I don't start filling out the census form in the first place, then I can't get fined for not finishing it, can I? Here is a very interesting letter from the Office of National Statistics in regards to the legislation, not law, governing the census. Dear householder, thank you for your letter dated 1st April regarding census 2021. It is important that everyone takes part in the census. It gives a detailed and comprehensive picture of our society. It is vital in ensuring that support gets to those who need it for investment in the public services, healthcare, homes and schools that people need. The information the census provides on the population, their characteristics, education, religion, ethnicity, Working life and health gives decision makers in national and local government, community groups, charities, and business the opportunity to better serve communities and individuals, enables a wide range of services, equalities, monitoring, and future planning to be supported in one way or another. It has an impact on the life of everyone living in England and Wales. The legislation that underpins the census, including definition of the householder and the penalties for non-compliance, non-completion even, are the Census Act 1920, blah, 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 blah. This legislation creates a legal obligation on all householders to complete and return a census form. Failure to do so is a criminal offence, yeah? Right. Further information about the census legislation is available from the ONS, the Office of National Statistics, that is, website. The Census England and Wales Order 2020 defines householder as in relation to an address, means a person who is a usual resident at the address and either A, owns or rents accommodation at the address, or B, is responsible for paying household bills and expenses there. Yeah, notice it never says a man or a woman, always a person, as I said in my previous video, one of them anyway. Man versus householder. You notice the legislation refers to a householder, exactly what I just said anyway. Resident and person, never a man or woman. This is why we should only ever identify ourselves as a man or a woman. Let's look up those words in Black's online law dictionary to find out some of their legal definitions. I say some because you'll usually find different definitions in different dictionaries. We have the lawdictionary.org. Residence. The difference between a residence and a domicile may not be capable of easy definition, as they are used in the New York Code of Procedure. The terms residence and resident mean legal residence, legal, not lawful, and legal residence is the place of a man's fixed habitation where his political rights are to be exercised and where he is liable to taxation. You hear that? Legal residence, yeah, his political rights, not inherent rights, political, under political law, the lowest law form there is. Yeah, statutes and legislation are above political law, but all of those are under commercial law, common law, etc. I'll do a video on my notes, my foundation notes, and go into that a bit more. And he's liable to taxation, yeah, a person, or, well, it says here a man, but you know, a man's political rights. Yeah, right. I'm not interested in political rights. I'm interested in inherent rights, common law rights, etc. The word inhabitant implies a more fixed and permanent abode than does resident, and a resident may not be entitled to all the privileges or subject to all the duties of an inhabitant. So an inhabitant has duties and privileges, or benefits and privileges. I don't take benefits and privileges if I have a say in it, because there's duties associated with taking benefits and privileges. House is not synonymous with dwelling house. While the former is used in a broader and more comprehensive sense than the latter, it has a narrower and more restricted meaning than the word building. In the device of a house, the word house is synonymous with messuage, whatever that word says, and conveys all that comes within the curtilage. Rogers v. Smith, that's a court case. A legislative assembly, or where the bicameral system obtains one of the two branches of the legislature, as the House of Lords, House of Representatives. Interesting, that. So it seems like a political term again, eh? political law, legislative. Also, a quorum of a legislative body. The name House is also given to some collections of whatever that means, other than legislative bodies, to some public institutions, and colloquially to mercantile firms or joint stock companies. So even the word house doesn't seem like a good word to use, eh? What is messuage? This term is now synonymous with dwelling house, but had a once more extended signification. It is frequently used in deeds in describing the premises. There's a court case, another one there, another one there, another one there. Although the word messuage may, there is no necessity that it must, import more than the word dwelling house, with which word it is frequently put in apposition and used synonymously. And that's a quote reference, I guess. The principal dwelling house within the barony bell. End quote. What is curtilage? The enclosed space of a ground and buildings immediately surrounding a dwelling house. In its most comprehensive and proper legal signification, it includes all that space of ground and buildings thereon which is usually enclosed within the general fence immediately surrounding a principal messuage and outbuildings and yard closely adjoining to a dwelling house, but it may be large enough for cattle to be leavened and couchant therein. What is quorum? When a committee, board of directors, meeting of shareholders, legislative or other body of persons cannot act unless a certain number at least of them are present, that number is called a quorum suite. In the absence of any law or rule fixing the quorum, it consists of a majority of those entitled to act. Another word mentioned is building, which has a more straightforward definition. What is building? A structure or edifice erected by the hand of man, composed of natural materials as stone or wood and intended for use or convenience. Senseless harassment. What is the Protection from Harassment Act 1997? The Protection from Harassment Act 1997 prohibits the pursuit of a course of conduct which amounts to harassment of another. Protection from a harassment. The reason I'm sharing this is because the people from the census kept ringing my buzzer over and over again until I said, look, stop ringing my buzzer. And then they stopped, luckily, because otherwise I could file a claim for harassment. In Hayden v. Dickinson, Mr. Justice Nicklin extracted the following principles from the leading case as to what amounts to harassment. Harassment is a persistent and deliberate course of unacceptable and oppressive conduct targeted at another person which is calculated to and does cause that person alarm, fear or distress. The behaviour must reach a level of seriousness beyond irritations, annoyances, even a measure of upset that arise occasionally in everybody's day-to-day dealings with other people. Wow, they use the word people instead of persons. The conduct must cross the boundary between unattractive and even unreasonable and conduct which is oppressive and unacceptable. The gravity must be of a level which would sustain criminal liability. A course of conduct must be grave before harassment is proved. Any course of conduct which causes alarm or distress does not automatically amount to harassment. The person ought to know that it involves harassment of another. If a reasonable person in possession of the same information would think the course of conduct involved harassment. The test is objective, is not swayed by the feelings of the claimant. Those who are subject to harassment can include others who are foreseeably and directly harmed by the conduct of which complaint is made, so they can be described as victims of it. Also, I've noticed that the census people, no matter how many times I send the form back, just keep sending me a new one. Well, they did eventually stop. That's as well as sending someone round every day to ring my buzzer, which is well more than 2 occasions, more like 7 so far. Now, take a look at this. Harassment is conduct that causes alarm or distress, and a course of conduct must involve such conduct on at least 2 occasions. Harassment is conduct that causes alarm. Oh, already read that. At least 2 occasions. So here's what I wrote on the back of the third census. They sent me to return to sender. The Protection from Harassment Act 1997 prohibits a course of conduct which amounts to harassment on at least 2 occasions. I've since told one of these people to stop ringing my buzzer, and after them ringing it every day for a few weeks or something, I haven't heard them call around for over a week now. There you go. Parking fines, etc. I have helped get rid of many debt collectors for parking fines using a conditional acceptance. Head on over to the Dealing with Bailiffs page to learn more about debt collectors. Also, if you wish to get rid of council PCNs, head over to my PCN page, or if it is just a private parking company issuing a fine, then head over to the page about writing notices. The page index should be found in the top right hand corner of each page. I will be doing a video on those pages as well. So we also have common law of the land, which is actually much simpler to understand and apply. To use this approach for a fine, you can write something really simple like, is there a man or woman that's going to come forward to claim that I owe him or her a debt? If so, I'll be happy to pay them. Although with the council fines, I wouldn't suggest doing that. There is a method I use for that, which, like I say, I'll be doing a video on the page. It is a pay to view process, but the introductory page I'll be doing a video on. And if you've paid to access that, I'll be doing a video going through that eventually too. Then there's the John Harris method shown above, which is simply to write on an envelope, no contract return to sender, and post it back. The only thing with this is you'll still get debt collectors knocking on your door, which is why I have a notice on my door outlining the law, also found on my Dealing with Bailiffs page if you want that. Here is the claim of right and affidavit to send to the Prime Minister that I mentioned. It, like all commercial processes, comes in the form of 3 notices: notice of claim, notice of fault and opportunity to cure, notice of default, a private default judgment. There's 1, there's 2, and there's number 3. The following document can replace the first notice above if you just want a standard affidavit to use with no claim of right or fee schedule, etc. added. There it is. An affidavit is the highest possible authority in law because it is a man or woman's word, and word is bond, stroke oath, stroke promise. A promise to pay is money. Remember, it plays the gold, so it is as good as gold. The same goes for witness testimony, obviously. To further your understanding of English foundational law, I recommend reading this book, Layman's Guide to the English Constitution by David Barmby. It's £30, but you know, I'm not saying you have to buy it. Maybe someone you know already has it. And also this book by Robert Arthur Menard. Yeah, Bursting Bubbles of Government Deception. Robert Arthur Menard. He also has a video with the same title, but the book is much more in depth. There's a link there button. If you'd like to see how I and some of my family have actually charged companies money for their errors, templates and process available for purchase, then head over to my notice writing page. The link is there. Here are some more interesting books on the law merchant. I will be doing a video on this page, as I say. Yeah, more books on the law merchant, international, commercial, maritime, admiralty, law of commerce. I haven't read any of these books, but I couldn't seem to find the in-depth one that I have read. You couldn't find a link to it to share, but maybe you'll find my t-shirt designs. Link further down, more interesting. Enforcement of Maritime Claims, that's the first book, and I'll leave you to go through these books, or you can pause the video to look at them. There's my t-shirt, which I've already showed all of this in the previous videos. If you've read this far and want to learn more, head over to the contacts page to send me an email for a free info pack. Otherwise, let's continue this journey by heading over to page 4A. A for V, that stands for accepted for value. So I'm going to end the video there, and we will be doing the next video on accepted for value, as I said. So thanks for watching. Take care, one love, and stay blessed.